So let's have a look at how we're actually making these changes, what will happen after the consultation. The Legal Services Board, the LSB, the new overarching regulator of frontline legal regulators like the SRA and the Bar Standards Board, has power to make recommendations to the Lord Chancellor under Section 69 of the Legal Services Act that the Lord Chancellor should make an order to amend the primary legislation as necessary to achieve the changes that I've just discussed with you. A proposed draft of the Section 69 order is annexed to our consultation paper, and you'll find it as Annex 1. It's possible that the draft Section 69 order may change a little. The new authorisation regime for sole practitioners will also apply to registered European lawyers or RELs who are sole practitioners. RELs can be a sole practitioner in the same way as sole solicitors can be sole practitioners. So similar changes are expected to be made in respect of those. Now we're going to have a look at what impact the proposals may have on, for example, equality, costs, competition and related issues. The Section 69 draft order proposes a change in the way sole practitioners are authorised, so they become authorised and regulated in the same way as other traditional business models, partnerships, LLPs, incorporated practices and ABSs. We consider it's important to have fairness and consistency to ensure an appropriate level of consumer protection. So please could you have a look at our draft impact assessment, which you'll find as Annex 2 to our consultation paper. In summary, we think that the Section 69 order will have minimal impact in terms of costs to firms, and that any impact is outweighed by the benefits to firms and the SRA. On competition, we think that the impact will be positive. We consider that sole practitioners and firms benefit from the removal of a requirement for annual renewal of their endorsement on the PC, and this will allow for easier transition when changing from one business type to another. But we want to know whether you agree with this assumption. If you don't, we'd be very pleased to hear your reasons. On equality, we do not consider that Section 69 order, that the changes thought about by the order itself will produce any adverse equality impact, but we would like to know whether you agree with this. And if you don't, could you please let us have your reasons in your response to our consultation, or possibly today if that suits you better. We are aware that there are concerns about what the actual authorisation requirements will be, and a separate equality impact assessment we're carrying this out on the new authorisation and practising requirements section of the new handbook. But we would like to know whether you consider that the proposed changes will have other benefits for sole practitioners. I've already mentioned the ease of transition from one business model to the other, and if so, we'd like to know what these might be. Equally, we're eager to know if you can think of any adverse impacts, particularly on any equality group. If you do, please could you have a think. If you do, please could you let us know what you think this impact will be, and also how you think we could mitigate the adverse consequences. Now, we're going to have a break at this point, and we're going to have one of our mini polls. And the question is, do you agree that the proposed changes to be brought about by the draft Section 69 order are unlikely to have any adverse equality impact? So vote yes if you think they're unlikely to have an adverse equality impact. and no if you disagree with the statement. And the votes are coming in now. And I think at the moment we are topping them up and still coming in. Still changing. Still. Right, I think that's fairly stable now. So the results of that are that 37% of people, 36% of people think that the order is unlikely to have any adverse equality impact. But 16% think there may be an adverse equality impact, and so we're particularly interested to hear what that impact might be, and so I do encourage you please to let us know of your concerns. And frankly, not surprisingly, 47% really don't know. Well, that's quite a respectable position to have, and there's nothing wrong with that. Thank you for taking part in that. So carrying on just briefly with the consultation, what happens next? Having reviewed the consultation responses, the LSB will then determine whether it's minded to recommend a Section 69 order to the Lord Chancellor. So essentially then the LSB will take over the reins. If it decides that it wishes to do so, it will conduct a short consultation, and that's expected to take place during May. And now we'll hand over to Karen, who's going to talk about supervision. Karen.
Thank you very much, Nikki. Supervision is about the oversight of all of our regulated firms. It is about us as the regulator ensuring that individuals and firms meet the appropriate standards that both the public in general and the individual clients expect. Supervision must be flexible and, importantly, it must be risk-based. Flexibility is the key to ensuring that we regulate effectively in the public interest. So, resource at the SRA in terms of supervision must be applied based on risk. We all know that the legal marketplace is in a period of great change. So at the SRA we must use our regulatory resource very wisely. So looking at the general principles, supervision will be based on constructive engagement with all shapes and sizes of firms. What do we mean by this? Constructive engagement is about having a meaningful dialogue with individuals and firms. It is about taking information which we already have or information which we will gather in. It is about us using that information to assess risk and then engaging the firm or the individual in dialogue about any relevant issues. Supervision is not about catching firms out. We understand at the SRA that in moving to OFR, firms will be getting to grips with a new handbook. For example, they'll be looking at the principles and the outcomes and how they can meet those. And we understand that for many firms, this represents significant change. Our approach is not to nitpick or to tick box. It is about us moving away from a heavy focus on the exact processes that firms have used to comply with our rules, to looking at whether outcomes are being achieved. And the benefit of OFR for firms is that firms will have much greater flexibility in how they achieve those outcomes, and importantly, how they achieve those outcomes for clients of the firm. So supervision will focus on how firms manage their own risks. And by this, I don't mean that we'd be looking to have complicated processes in place. What we mean there is good business management. So sound financial management with aspects of business planning. We'd be looking at firms who ask themselves, what are my risks and how can I deal with them? So moving on to risk. All regulated firms will be supervised according to risk. We set out in our November policy statement, which is available on our website, our risk-based approach. We will seek to identify the risks to us as the regulator in us meeting our regulatory objectives. And that emphasis there is key to understanding our risk-based approach. So if you haven't already read the November policy statement, I would really urge you to do so. The assessment of risk will be used to increase scrutiny in our authorisation of new firms, and as I've said, in our allocation of supervisory resource as well. But as Nikki said, that risk assessment is reliant on information. So in order to analyse and assess risk, we will use information from a range of sources, including stakeholders and firms. And in that regard, we will need more information from you. We will therefore require information from all firms on authorisation, by virtue, for example, of notification requirements in the draft code. And I'd refer you there to the requirements in Chapter 10 of the draft code. And also as part of an annual reporting process. But we at the SRA also know that we will always need to respond reactively to some risks and events. This is inevitable, and it's right and proper that we do so. But we will focus on only reacting to events and risks which we think are of regulatory concern. And this will also enable us to use our resource in proactively dealing with emerging risks. So in respect of the range of supervisory approaches, what will they look like? Supervision will still include us visiting firms. This could be as a result of responding reactively to a notified event, or as part of a proactive programme that we put in place, looking at a type of themed risk. For example, we receive a number of complaints about a certain area of a firm's work. We will visit the firm to find out what is going on. Why are the clients complaining about just a certain aspect of the firm's work? We'll look across the firm in terms of whether you're achieving the outcomes. We may also make periodic visits to certain firms, only if we think there is a risk basis for doing so. We will also undertake desk-based supervision. So this means that we will use the means of telephone or email contact to engage with you. Again, this may be in response to an event which has occurred or to an emerging risk which we have identified. For example, looking at some of the notification events in Chapter 10, we would telephone you to discuss the matter. We may ask you for some more information, or we may refer you to useful information on our website which could assist you. The emphasis here is about constructive engagement. It's about a meaningful dialogue, getting to know you and your firm, and dealing with the issues in a risk-based way. Supervision, as it is based on risk, will vary across our spread of regulated firms. So for firms we consider to be low risk, a firm's experience might be termed as low intensity, and again I would refer you to the November policy statement where this is set out. So what would this mean for low risk firms? It would mean that we at the SRA would only contact you when we needed to. That low risk firms would not be subject to periodic inspections. And any contact that we have with you would be driven by the risk assessment of an event or as part of one of those themed risks which we have identified.